Good morning, everyone, and I'd like to welcome everyone to the Committee of Conference session on Senate Bill 458, which is relative to the Sununu Youth Center and operation of a replacement secure facility. For the record, I am Senator Sharon Carson. To my right is Senator Sidney Rosenwald and Senator Jeb Bradley. And to my left is Representative Kim Rice, representing the House, Representative Mary Jane Wallner, Representative Deb DeSimone, and Representative Keith Erf, representing the House. So, who wants to begin?
Well, I kind of thought we'd begin and then.
Okay, well, Senator Bradley, do you want to take it from here?
So maybe we should identify big issues that exist between the Senate.
Okay.
So obviously the census number is a big issue. Based on what I've heard, I think it's the willingness to meet in the middle 12 with expansion to 18. Maybe I'm incorrect about that. That's one issue. And I think the larger issue for me is the difference between the Senate passed version of 254 and your version of 458, section 8 in particular. And the sort of lack of better word called juvenile justice reform. I think there's some significant differences there.
Okay. So why don't we begin with the discussion on the bed issue? We'll start there. Representative Rice.
Thank you. So I'm just going to state right now, I don't know if I can get an 18-bed facility passed out of the House. That's the big concern. I don't know if I can do that. I'm just being honest.
Is there any particular reason why?
It could have something to do with the $100 million we're paying out already for the plaintiffs from SYSC. I think it's safe to say that people have concerns over placing kids in these facilities, and they're looking for other options as to not just necessarily throwing them in a juvenile jail. And to be quite honest, I think that with the number of kids that we detained, I don't know why they have to be placed at SYSC when there are level 4 facilities, level 3 facility group homes that these kids can be put in instead of placed in a juvenile jail with kids that have already been convicted. That's where I am. Does anyone else have anything to add?
Cuddle up with you.
Okay.
So from my point of view, we're kind of in between state right now in terms of the bed count issue. And quite honestly, I don't see the point of building a new 18-bed facility rather than retaining the current facility for the time being, if those are the choices, until we have a clearer idea of what we really need. I think we on this side think 18 is just too high. And honestly, I think that's the sense of the House from my point of view as well. So that's my big concern is, well, why build an 18-bed facility now, which seems to be overly large, even by current metrics, not even thinking about the fact that that facility is, out into the future. Thank you, Mr. Chair, Madam Chair.
Representative?
Thank you, Madam Chair. Just to expand a little bit on what Representative Rice had to say about children's residential care. we have available between level 1 and 4 up to 459 beds for kids who have yet to be adjudicated, as opposed to them sitting with kids who have been committed. Level 4 care beds for the kids who have committed the most egregious crimes. There are 302 beds right there. So this is why I think that we're going to have an issue with trying to pass an 18-bed, because we do have other options available.
Senator Bradley?
Well, it seemed to me, and I'm not sure I'm fully understanding what the position is. I mean, I'm hearing that nothing with 6 beds in a state facility will pass. That's, I think, is what Representative Rice said. But I'm looking at the House passed version, which is 6 beds. So you've already, it would appear to me, committed to, you know, a state-run facility of 6 beds. I think that I'd be willing to go to 12 beds with a surge capacity of up to 18. I think that there has to be a place that people that should be separated from other juveniles can go, that is run by the state. And I get the $100 million problem, but a lot of that happened, you know, 30, 40, and 50 years ago. And, you know, I think the state is stepping up with 1677 to, you know, make those wrongs, you know, at least somewhat better for those victims. To think that, you know, in the Senate heard testimony that private sector beds or not-for-profit facilities have had these same problems too. So it's, I don't think we can just avoid building a state facility for, you know, some of the numbers. And since we started this process, I think back in 2017, the census has dropped dramatically to the point that we're at about 12 right now. And that seems, if we built to 12 with, you know, a surge capacity because of, you know, the need to separate males from females and other issues that would require, you know, potential surge capacity, that seems reasonable to me.
So if I may, I don't think the representative was saying that we need to privatize. The representative was stating that the way we lower the census is by detaining these kids at these other facilities rather than keeping them in the secured facility. I didn't hear her say anything about privatizing or not building a state-run facility. Right? It was just about the numbers and how we can lower the numbers by putting detained kids into the group homes, perhaps in their communities, to where they can start receiving services. Because if I'm correct, I don't believe when kids are detained at Sununu, they're not even there long enough to start getting services. So if we put them in a place, perhaps that maybe they could start right away and keep them out of jail with kids that have been adjudicated and learning how to be better criminals. I really want to see these kids have a shot. And I just don't think by locking all these kids up into a juvenile jail is the answer. If kids are detained, they are, you know, they should be, we contract with all these places. I'm not sure why we're not sending kids there that are detained rather than placing them in the juvenile jail. And that's where I believe the representative was coming from, that she was not stating to not build a state-run facility, but she was referring to how to reduce the numbers.
Well, if I can respond, I think we've been in favor of reducing the numbers, and that's happened since, I believe, 2017, you know, when Senator Carson and you, Representative, you know, worked on this issue in the, I think it was House Bill 2, Representative Rice. So I think we share that goal, but to say that we're not going to build a facility, a state facility, to house those that need to be housed, it just, I don't know, I don't think that makes much sense. And we
But
certainly
again-
heard significant testimony, and Joe Ripsum is here,
Yeah.
that the department thinks that we should be building a facility too. So I think we should be listening to the experts that are responsible for operating this. I know we've had problems in the past, but I think the light of the sunshine has been on the Sununu Center, and to think that the same issue is going to replicate itself in a new facility with better supervision and the protections in place and some of the other reforms that have been implemented, I just don't see why we wouldn't build a facility that houses roughly the number of juveniles that over the last couple of years, we have gotten to that point.
Representative DeSimone?
Thank you, Madam Chair. Just to make myself clear, Senator, I'm not sure whether we need to build anything, and I'm not sure that that should be set in stone. There are other possibilities. I am sure that we do need a facility for those youth who have been adjudicated and have been committed. The other youth who are being detained prior to adjudication, in my estimation, have no business being in the same population as the kids who have been committed. We are creating another issue there if we mix them. That's my only issue. I'm not saying that we shouldn't build anything or rehab anything. I'm just saying that the census is actually a little bit lower than what we think it is.
Senator Rosenwald?
Madam Chair, every month, almost every month, Fiscal Committee gets a report from the department that includes the number of detained and committed children at Sununu Youth Center. And right now, for the past, I don't know, a few months anyway, we've had 7 or 8 committed youth. So if we were to follow your suggestion, 6 beds wouldn't actually be big enough. It would be a little too small. Plus, we sometimes take kids from Vermont, which there's no reason we would need to continue to do that. But of the committed children, there have been more than 6. Thank you.
Thank you. At this point, I have to agree with my Senate colleagues. I think we're putting a constraint on the court. The court is the one that's going to be looking at all the evidence, all the facts, and they're going to make a decision about where they're going to place that child. And if we build a facility that's too small, aren't we constraining them? They're saying, well, there's only 6 beds. This kid needs to be in a place where, there's a lot of supervision, so on and so forth. So we don't have the bed, so we're going to put them into a different type of facility. I don't think that we should be doing that. That should be left up to the court, not to us. And we have to build it so we can hold these kids. Yes.
I agree with Senator Rosenwald that last few months, the data has been showing 7 or 8 detained children in that facility. We have to remember that within the House bill also is the wording of 254. And that will further reduce the number of children that will go into a state facility. So I think that we really probably are looking at something closer to 6 than we are looking at 12 to 18. So I think that we need to always consider what will happen with 254 and how that will be considered.
Okay, thank you. Just so the audience knows, House Bill 254 was attached to Senate Bill 458, and the Senate position was interim studied. So I don't see the Senate moving from that position at all. So
if I could just.
Excuse me.
I'm sorry. Sorry, go ahead.
Wow, okay. We are holding to our position on 254, and if the bed size is predicated upon 254, for us, 254 is off the table. So we're only dealing with the Sununu Youth Services Center. We're not dealing with 254.
I think we are, because it's in the House position, so the House is dealing with you.
Okay.
Because that's in the House position. And I wanted to show Senator Bradley his language in a floor amendment for HB 1661, which is extremely similar to the language in 254 as passed by the House.
Mm-hmm. Okay, but we do have House Bill 254, and the Senate interim studied that bill. Yes,
The House non-concurred with 254.
correct.
Right.
Yeah.
We worked with Representative Lynn on the language in 254, and perhaps it'd be good to hear from him about some of the key differences between what you did in 458 and what we did in 254. I mean, I think property crimes, or the potential of property crimes, just should not be eliminated off the board and say nobody's ever going to be detained for committing property crimes. And my understanding is that the way the House passed version of 458 is written, that would be the case. And that, to me, it just goes too far and undermines public safety.
Okay. So Representative Lynn, would you like to come forward?
The proposal that the Senate amendment to 254. I'm sorry, thank you. The Senate amendment to House Bill 254, I think, and I'm speaking personally, I understand that that's not the House's position, but I think that the Senate amendment to 254 was a very valuable amendment, because what 254 as adopted by the House said that there are no circumstances that in which someone who has committed a nonviolent property crime, no matter how serious the crime was or what kind of a background, how many times the person might have done it before, there is no possibility that such a person could receive a committed sentence unless, and they added a subsection M in the Senate version, unless the person posed a risk of serious bodily injury. So that it was back to the only committed under any circumstances was a person where there was some threat, some threat of physical injury. The amendment that the Senate adopted expands on that by saying that there can be a possibility of commitment where the person poses a risk of substantial danger to of destruction or damage or theft of property, or where under all the circumstances a sentence of commitment is the only appropriate sentence. The judge determines that it's the only appropriate sentence that could be imposed. And it also, the Senate also added what I thought was a very valuable this was not in my proposed amendment, but I thought the Senate adopted it. And I believe it was probably at the suggestion of someone from the juvenile justice, I've forgotten the name, suggesting that in circumstances where there was a plea agreement, that might also be that the defendant represented by counsel in a plea agreement agreed to a committed sentence, that it could then be imposed. And I thought that was an entirely appropriate suggestion also. So I do think that the Senate position on this makes a lot of sense. I'm happy to answer any other questions.
Okay, thank you. Senator Bradley? Did you have a question? I didn't know if you had a question.
No, I just want to thank Representative Lynn for helping us with this. And I know the difficult position you're in, you know, the House position being one that's slightly different. So I appreciate that. I just want to thank you.
Thank you. Okay. Is there any further discussion? Representative Irf?
Thank you, Madam Chair. So I guess I make a couple of points, and the first one I'm going to make is probably speak a little bit out of turn. I didn't realize we're jumping into 254 so quickly. But I would just say from my own perspective that if we're going to go down that road at this point, I'm guessing there's probably room for compromise there. And perhaps that would be a point that we would need to speak amongst ourselves about that possibility. But going back to an earlier point, that Senator Bradley made, Senator Bradley made, regarding the bed count. I think, I understand the current census, at least as of March 24th, was 11 kids and 11 less than 12. I get it, that's greater than 6. It's an easy comparison to make. But when we're talking about the desired bed count, we should speak to the time frame in which we expect this facility to open. Now, if we're talking about a rehab, maybe we're in the 1 year, 2 year type of time frame. However, if we're talking about a new construction, both the House and the Senate bills basically put that time frame out to 2026. So that's 4 years from now. Now, when the director of the DCOIF spoke to us, he gave an eloquent explanation of the system of care. And I know I'm new to the world here, and I acknowledge that, but I have been sitting on the Division 3 listening to the testimony for the last 4 sessions. And a big part of that testimony has related to the system of care and the pretty substantial amounts of money that we're spending both in years past and going forward. And the director, when he spoke with us, he acknowledged that, well, he acknowledged the wrong word. He said that in the immediate period, right now, in the next couple of years, it would not have any impact on the census. But looking forward and following, should I stop talking?
I know. The lights went out. It's like, oh no, brownouts already. Maybe somebody on the outside hit a light or something, or lights blew. I don't know. Oh well. Who knows?
So following the trend lines we've been on already, we came in at 70, I think was the rough of the census when the director started new here 4 or 5 years ago, and then it's been going down ever since. And he indicated that the system of care, while it hasn't kicked in yet, it has kicked in the sense that it's starting to pick up the younger kids, the 10-year-old, the 12-year-olds. And the whole point of the system of care, and again, this is as explained to me, I'm not an expert, I'm a computer science guy, is that you pick up the younger kids and they're in the system for 3 or 4 years, the younger kids that are a problem, and they're in the system for 3 or 4 years. And during that time, you're able to help them avoid the track that would have taken them into the situation. And he acknowledged that he expected that census to drop in that 4-year timeframe. Didn't give specific numbers, but said that it was coming down. This is why I was referring to this transition period that we're in when I spoke earlier. I think we do find ourselves in a time period where it's not exactly clear what the proper size is. And to make an investment in an 18-bed facility, and by the way, I just my own personal perspective, I don't really draw a distinction between 12 with a surge to 18 and 18. You're basically building for 18. And we built the Sununu Center for 144 kids, and I don't know that it ever had that number in it. I hate to see us make that same mistake now, not having the information to make the right choice, whether it's 12 with a surge, 6, or something else. But I don't believe we're in a situation where we can definitively say we've got to have 18 or 12 with a surge to 18. Thank you, Madam Chair.
Thank you. Are there any further discussions at this point? Because I think because we've pretty well laid out where we are, it might be appropriate for each body to perhaps caucus, and we can come back perhaps in 15 minutes. And,
We hear from Director
Sure.
Ripson.
Director Ripson, please come forward. So that way we can talk amongst ourselves and see where we are. Good morning, Director.
Good morning, everyone. Joe Ripsum, Director at ECYF, for the record. If folks have questions, you want me to just jump into what I'm thinking?
Just jump right in.
Okay. As has been shared at multiple committee hearings in both chambers over the past 6 months, the department's position on this is that building to 18 beds is an appropriate building. That's not because we believe we're going to be serving 18 kids at any given time. If we look at the data over the last few years, right, others have said it, we went from a place when I first got here to having 75 kids in that building to today having an average of 12, which is remarkable. It's like 600% reduction over 4.5 years. It's remarkable progress. We're currently one of the states that have the fewest number of detained and committed kids in the entire country. I think somewhere like the 4th lowest. So I don't know how much further we can go, but I do think we can do better. As Representative Erf said, I fully believe that when we build out the system of care and that when young kids are accessing those services now as young kids, over time we'll start to see fewer kids end up needing that high level intervention. So all of those things are concurrently true, and I think that puts us in a position where it's pretty complex to think about what the right number is. Nevertheless, we still land that if we're building something now, that the right number of beds, not the right number of kids, but the right number of beds is 18. And that's because we need the flexibility to serve males and females separately and to separate populations based on clinical needs. Oftentimes we'll have 2 males that cannot be together for various reasons. And we also need to separate populations based on court orders, where we'll have 2 youth who are committed in a common offense, and the court's ordering us not to have those 2 youth have contact pending their charges. A couple other things I would like to say in terms of separating out the detained population from the committed population. We did make a choice to mix those populations because it got the census became so small and variable that it almost became ridiculous. Some days you'd have 1 detained kid and 10 committed kids. Other days you'd have, if you look back at that data that I shared that has the day-to-day count, you'll see days where we have overwhelming number of detained kids and almost no committed kids. It just, the census got too small to operate separate programs. Same things with the genders. Once the census gets that small, you have to separate them for sleeping quarters and getting dressed, but for programming during the day, for school, they go to the same classes together. Again, because once the census gets that small, separation for those purposes becomes really silly operationally. And you get to the point where you're operating separate facilities, the economies of scale, which are already so small that make the per daily rate cost incredibly high, would get even higher. So those are the reasons why we've made the decisions to kind of make this one facility for all. Now, I did hear some comments around the idea that we have a bunch of residential programs that some of these young people could go to. I would caution, right, these residential programs are not built for the juvenile justice population exclusively. Every residential program in the state serves the child protection population, the behavioral health population at large, oftentimes education programs, and the juvenile justice population, and placement decisions are based on the clinical needs of the kids, not based on the offenses that brought them into the system. As far as I'm concerned, that's the appropriate way to build a system. We want to be focused on kids' clinical needs. But most of the kids that end up detained in our system are kids who have gone through many of those programs. Our level for ERT programs, which were the ones that were created for the purpose of bringing a lot of kids out of SYSC. Those same programs are one of the highest sources of kids that end up being detained at SYSC because of behaviors that exist within those programs. That's a problem, I think, in terms of us doing a better job of serving those kids in those programs, but it doesn't make those places the solution for those kids to go in the immediate term. We need to keep working on trying to figure out how to make those kids stable in those programs. Right now, SYSC serves a purpose of helping stabilize those programs, and we heard that testimony from the gentleman who runs those programs back in September when the committee to study the closure of SYSC was meeting. The gentleman that runs those came in and said he needs a program like SYSC sometimes to stabilize kids and get them out. Again, I don't think that's ideal. I think our ideal is that we work to figure out how to stabilize those kids where they are. But the idea that we're going to just eliminate that piece of the system, I think is really problematic. And I shared with folks last night on the committee data that was shared with Division 3 a couple years ago. I did caution that that data is not the best because it's based on hand counts out of case notes. It's not based on data on fields that are actually in our data system. But if you look at that data, the overwhelming majority of kids who have been detained and committed to SYSC have a long string of offenses. This isn't a kid that committed one act and is getting sent in. These are kids that have multiple simple assaults, and even on that point, those simple assaults are often pled down from more egregious crimes because prosecutors know that they're able to access SYSC if they need it by pleading down to simple assault and having the youth enter there. I very much worry that if you change that system, that what you'll end up seeing is a reduced likelihood of a prosecutor to plead down to a simple assault misdemeanor and instead charge those youth with a felony, which is going to end up having longer term ramifications for them, or charge those youth as adults. And if you charge those youth as adults, not only does it have longer term ramifications for them, but then they potentially get committed to SYSC for the remainder of their minority and then move into the adult system. So I think when we mess with these parts of the system, we have to be really, really thoughtful about how other players are going to use the laws that we create. And I worry that some of this conversation hasn't really thoroughly worked through all of those contingencies.
Thank you, Director Ribson. Are there any questions for Director Ribson? One of the things I would like to say that we had some testimony or discussion about kids being exposed to other kids when they're in a committed facility. Kids are there because they've committed a crime, and then you're detaining kids who have been accused of a crime in that same facility, that there's, I guess, maybe the possibility that they're going to get corrupted by those other kids. But isn't it the case, if you're going to put a detained kid into a group home with other kids that are there for other potential reasons, that you can have the same thing happening? That they are going to corrupt the other children that are there for totally different reasons.
So you try to address that in both settings through the way you structure your programming and the way that you group your youth together, right? So part of what I talked about the importance of being able to separate youth based on their needs is to get exactly to that sometimes we have young folks in there who have committed some really egregious things and really are dangerous to the other kids and could be, a really rough influence. And those are kids that we'd want to have separate from the kids that don't have quite that intensity. And I think it's the same thing that happens within the residential programs, to try to manage those through the way that you separate kids and the way that you implement the programming for kids. But it is true that we do have kids in all different programs that have committed all different types of offenses. I think one of the key things that we try to work at, which might be counterintuitive to many people, is that we don't really make these decisions based on their offenses, right? The initial decision as to whether a kid goes to SYSC or not is based on an offense. But the decision about where should they receive the best treatment to rehabilitate them, those are not based on their offenses. Those are based on a clinical understanding of what their needs are, and then sending those youth to the right programs. So it's complex, and it's a lot more complex than thinking about, in a lot of ways what the juvenile justice system should be is a behavioral health system. But you have this juvenile justice overlay that you have to manage and work with, and it's appropriate and necessary, right? And that's why I think sometimes when we try to affect this solely from the space of offenses, which is one of the things that I worry about that we focus on, we lose sight of the real issue, which is understanding what these kids' needs are and making sure that we have them in a place that can meet those needs. And one of the things that I'm really grateful for is that both versions of this bill put a high focus on that in the creation of a new facility. They focus of it, both versions of this bill focus very clearly on elevating our trauma-informed care, on making sure that we have a clinically appropriate setting, and that the whole thing is integrated within the system of care. And that's critical, right? Using the exact same assessment that we use for the rest of the system of care, the exact same care management entities that work with kids outside, working with kids inside so that we can facilitate transitions well. The whole idea is really trying to bring all of these young people into our system of behavioral health care in order to meet their needs and move them out of the juvenile justice system.
Representative DeSimone?
Madam Chair, thank you for taking my question. With the kids that are currently housed, how many of those kids are from Vermont?
The data that I shared yesterday has 0 Vermont kids. We took that data out because people had asked me to, since the contract with Vermont started, they didn't want to muddy the waters. We do today have 4 kids from Vermont in SYSC, but in the future state, I'm assuming we're not going to continue that relationship.
Isn't it true that that contract ends in October?
The current contract ends in October. There are renewal options, but there hasn't been a decision made about whether to renew, and some of that will obviously be impacted by what decisions are made now.
Thank you.
Yes.
Mr. Ribson, what happens if we only build 6 beds and we get 10 kids? What do we do with the other 4?
I'm very worried. I mean, the biggest concern would be, what do you do in the immediate term? I mean, we already find ourselves scrambling over the past couple of years, particularly, in a post-COVID world where residential programs were not accepting kids because of COVID. Today, many of our residential programs, we have many, many contracts for many, many beds, but most of those beds many of those beds are not available because the workforce issues that all of our providers are facing, putting a real clamp on the ability for them to accept kids. So I do very much worry that even trying to get these young people into residential programs could fail, and then you end up looking far and wide. And in the immediate term, that poses a real problem. And I worry about us being in a position like Vermont found themselves in, where they're sending kids to adult facilities and creating little makeshift kids units, which is terrible. Or sending kids to hotels with armed sheriffs watching them 24/7, which is terrible. You need to have the right facility to hold these kids, even if it's temporary, to move them out. And what I'm grateful for in this bill is I think it really does push into that space of building something that's trauma informed and clinically focused for kids that can work on stabilizing kids and moving kids out. But the alternatives are pretty rough if we don't have sufficient capacity.
Is there any guarantee if you did not have the capacity and you had to send the kids out, that they would be any place located near their home, their family, they would be out of state someplace, which would cause a huge issue for the family?
It causes a huge issue for everybody. It's an issue for the family. It's an issue for the staff who want to maintain relationships and visit. It's an issue for the young person, making it really hard for them to integrate back into their community. It's incredibly expensive. There's lots and lots of reasons why it's a bad idea. And we currently have kids far away. And one of the things that the state is working on right now in the acquisition of Hampstead is building what's called a PRTF level of care within Hampstead, which will allow us to bring some of those kids that are far away back to New Hampshire, which is a great thing. But that's a piece of our system that's been missing for a long time. And if we were to do something that was to exacerbate that, we would find ourselves again sending kids far away right at the time that we're finally getting close to bringing them back home.
Thank you. Are there any further questions for Mr. Ribson? Okay, seeing none. Thank you very much, Mr. Ribson. So I have 10. I have 10 after 10. Why don't we take 15 minutes, 5, 10, 15, come back at 25 after, and see where we are. Okay. Thank you all. actually 10, let me go here. It's after 10:25. We're going to go ahead and reconvene. The Senate has determined that we are sticking with our requests, that we adopt the Senate version of House Bill 254, and that we expand the number of beds from 6 to 12 with the capacity of possible 18 beds. And Senator Bradley, was there anything else? We end up just starting to talk to each other and forget about the mics. Good morning. I would like to welcome everyone to the committee conference on Senate Bill 301, an act relative to the procedure for violations under the right to know law. Okay, so let's have a discussion. It seems that, and I'm going to turn it over to Representative Gordon from the House.
Yes, thank you, Madam Chair. On Senate Bill 301, you sent us Senate Bill 301, and we were concerned, I think, at the time in the House Judiciary Committee that the ombudsman, the right to know ombudsman bill, might have some difficulty as it went through the other chamber. And so we amended Senate Bill 301 to put on our original House Bill 481, which was the ombudsman bill. That House Bill 481 did go to the Senate. The Senate made one significant change in the bill, which I think we recognized as an improvement. It had to do with de novo hearings. And so it did away with the de novo hearing and indicated that that appeals, instead of being de novo, would be on issues of law only.
Correct.
And that the facts of the ombudsman would be accepted by the court. And so we agreed that that was an improvement in the bill, so we concurred with that bill. And that will be going to the governor. So at this point in time, it doesn't appear that there is a need for 481 as it was sent over to you by the House. A need for 301 as it was sent over to you from the House,
Okay,
if that makes sense to everybody.
okay.
So,
Senator Khan?
yeah, so, thank you. The amendment then that's on 301 is no longer needed. 301, Senate Bill 301 in its base bill is still one that the Senate sent over for your approval. So I think that then the Senate position is to hold with 301 because House Bill 481 we've agreed to, we have agreement on. So I guess to the House members, is it agreeable to drop to accede to the Senate position?
Yeah, there was concerns during the public hearing on the Senate version of the bill as it came over. There were actually a lot of additional burdens put on the people filing the claim with respect to documentation and things like that. So really the feeling was that the ombudsman bill was the superior approach. And that's another one of the reasons why when we amended it, we just incorporated the ombudsman, because the overwhelming testimony was in support of really giving that some wings to fly and choosing that as a path forward. So that's why, you know, we have reservations about the version that came over from the Senate, and we really wouldn't be looking to accede to that at this time.
Okay.
Oh. So is it your intent with the amendment on 301 to have a subsequent approval of the original House bill? No?
So no, when you say the amendment to 301, the House put on an amendment. That amendment is moot because both House and Senate have already passed the language of that amendment as modified by the Senate, and we think that's better. So that part of it's moot. The only thing that's here we could discuss is the value of the original SB 301. And our initial discussion of this in the House was that it's likely to cause confusion and conflict between the ombudsman process and what's being added to 91A by this. So we would rather just not do it at all. We were gonna, and that's what we were going to do until it was suggested, well, we could just tack 481 back in and give ourselves a second bite at the apple if we need it. But aside from that, we were not enthusiastic about this at all. We're not enthusiastic about directing the court as to how to conduct the procedure. I personally think that the whole Roman one is redundant. And I mean, I don't like the language that's in it anyway. So, but the real reason we didn't want it is we don't want to have any conflict. We want the ombudsman to go into effect and see how that works. And then if we have to do something with the court system, that would be the time to do that, but not until we see if the ombudsman process actually works.
Senator French?
Taking it in.
Okay. I just want to make sure that I understand this. You took most of the language from 301, is that what you're saying? And put it on 481?
No, we replaced the entire language of 301. We threw out the entire thing
Okay.
and just put the original 481 in its place, which is
Okay.
now redundant.
Okay. All right. They're having a little conversation here.
Right.
Good.
Would the Senate like to caucus here for a few minutes?
I think it's a good idea.
Okay, great. The committee will be in recess until 20 after, is that? Okay, I think that's good. Okay, great. You want to just go across the way?
If they're gonna give us this one.
Seeing that it's 11:20, we are going to reconvene. Are there any other comments or questions? Senator Khan, were there any comments you wanted to make?
You know, I think we will likely walk away from this conversation, and thank you for your consideration of our amendment on 481. That's good progress. Appreciate that. It's still our belief that there are elements in the guidance to the Superior Court that are contained in this Senate Bill 301 that are worthy of consideration. Hope that that happens at some point in the future, because we were just discussing the burden of proof, which this is trying to address. And the burden of proof on the plaintiff is not necessarily where the burden of proof of having disclosed all information that needs to be disclosed resides. It may reside with the defendant, the municipality or governmental agency, and this was trying to level that playing field. So it was a worthy bill. Hopefully you'll find a way to concur with that in the future.
Yes, Representative.
Yeah, so I have to agree. If people choose, because with the ombudsman, that's a voluntary process. They don't have to go there. They can go directly into Superior Court. And if they do, there are parts of this that are valuable because the plaintiffs have difficulty getting their information in front of the court. Right? So hopefully that we won't hurt many people by not doing this at all, and that we can work out something where when that avenue is taken, it will be better than what it is today.
Are there any further comments? Okay. Seeing none, thank you all very much.
Thank you, Madam Chair.
Okay, good. Okay. Good morning, everyone. I'd like to welcome you all to the committee conference on Senate Bill 302 FN, an act establishing the Personal Privacy Protection Act. Okay, we've been given a side-by-side. We've also been given an amendment from Representative Gordon. Would you like to walk us through your amendment, Representative?
I would. Thank you, Madam Chair. This is Amendment 2022-2017H. It's very much incorporates the language which was both in the House versions and the Senate versions, but makes a few changes. When we received the Senate Bill 302 from the House, we made one amendment to that, and that was to give the Attorney General's office more authority to obtain information from charitable organizations. And subsequently, there were concerns about that, several concerns expressed about it in terms of the state's ability to look at charitable organizations and perform the duties it's required to do by statute. So this amendment is intended to address that specifically. It just makes a few changes. One of the changes is under RSA 91C2. Under the House version and the Senate version, the current law or the current draft of the bill 302 provides that there is an exemption from the prohibition for disclosure when an individual voluntarily releases information with regard to their membership or the fact that they're a donor, and they release that information at a public meeting. The amendment that's proposed changes that to say that now, if the individual or the entity of which they are a supporter or a member or a donator voluntarily releases their status, to the AG or to the public, that would be an exemption from the prohibition. Then the other changes are under RSA 91C3. And that amendment deletes, frankly, it deletes the House amendment that the House put on it altogether. And it deletes some of the language that the Senate had added to the bill as well in its original bill. And it clarifies that the AG's authority to request information from a charitable organization for the limited purposes of RSA 7:24, and that's for audits, examinations, and reviews, and it specifically adds reviews. A very important addition is that the amendment defines the terms volunteer and supporter, and that includes individuals who, and it excludes from that definition individuals who are part of the governance of the organization. And finally, the amendment exempts from the prohibition for public disclosure the names of supporters, volunteers, members, or donors if they are the subject of either criminal or civil court proceedings brought by a government agency. I understand that the Attorney General's office has reviewed this and finds it the amendment acceptable and improves the bill, and no longer has a specific objection to the bill, and would offer that amendment for approval by the Committee of Conference.
Thank you very much, Representative Gordon. Are there any comments or questions from the Senate side of the table? Senator Whitley.
Thank you, Madam Chair. I just have to say for the record too, that I actually, I didn't support the underlying bill, and I do think that the whole bill is unnecessary. I mean, I think that there are already protections. My understanding is that we're trying to protect donors and encourage charitable giving. And I think that, this is just not necessary. Donors already have protection. The U.S. Supreme Court has sort of done a number of balancing tests on it. So I just have to say for the record that I just don't think the bill is necessary. And, there has been a lot of fiddling with it, which tells me that it's just not ready to move forward, that there are some unintended consequences that are still really problematic.
Okay. Representative Sylvia?
Thank you, Madam Chair. Just a curiosity, I guess. I'm not particularly familiar with USC section 7.8. It looks like little o-3. Is that proper coding?
I believe that was in both the House and Senate versions.
Yeah, it is, but it looks kind of funny as I can go through this looking for all the fine details. So.
Representative, I think we can rest assured that if it was, if it hasn't been cited correctly, that OLS would have picked it up and made the corrections.
Okay,
So
thank you.
you're welcome. Are there any further questions or comments on the proposed amendment? Okay, seeing none, why don't we take a 10-minute break for the Senate to discuss, and we will be back in a few. Going back to my room.
Back to the cave.
It's not a cave. Usually we go across the hall, but they've got locked the door again. coming out of recess, I would like to make the motion that the Senate accede from its position and we adopt the House amendment. Okay. All in favor, say aye.
Aye.
Aye. Any opposed? Okay, we're good. Thank you all very much.
Okay, are we ready to go? All right, the time being 12:15, I will call this committee of conference to order. And with us are Senator Daniels and Senator Rosenwald and representatives. Do you want to introduce House members?
Sure. I'm Representative Roy from Rockingham District 32. We have Representative Umberger, Representative Turcott, and Representative Abbott's here.
Okay, so you amended Senate Bill 401. Why don't you detail the changes?
I'm going to ask Representative Turcott to go ahead and do that.
We amended Senate Bill 401 simply by adding HB 1337, which is a indexing of unemployment benefits. That bill passed out of our House originally with only 3 Republicans voting against it. When we added it as amendment to SB 401, there was only 1 individual. It's been discussed in the House hearings pretty fully. It was discussed in the Senate when I introduced it here, although that when I introduced it, 2 of the 3 Republican senators on the committee left the room and handed the gavel to a Democrat. So it's an excellent bill. If you'd like me to get into the particulars for anybody who has not seen it, I'd be happy to do that. That's up to the chair.
Go ahead.
Sure. Basically what it does is it ties the length of unemployment compensation to the unemployment rate at the state. As of right now, the maximum unemployment benefit is 26 weeks. That would remain unchanged. That 26 weeks does reduce by, for each 0.5% reduction in the unemployment rate. So when you get down to a low of 3% or below, that number reduces to 16 weeks. The original bill, when we put it forward, the numbers were a little bit higher, lower than that. We actually had a maximum at the time, I believe, of 20. We reduced that down, or we increased that back to the current 26 weeks. Many states have already employed this. Every state that it's been employed in, it actually works well. I do understand that in New Hampshire, we have a fairly decent system now, and this is this bill is we're not decrying our current system, only that we have the ability to make our system a little bit better. The ultimate beneficiary of this will be several. The first one will be the businesses in our state who are going to see their unemployment insurance rates go down. Now, ours are already low. I understand that. So were some of the states that put this into effect, and those unemployment insurance rates went down. That frees up money in those businesses for A, growth, B, hiring more employees, higher employee wages, all kinds of different uses for that money saved. I was just reading a few brief comments on a piece of paper that was put out earlier. One of them was that we saw during the 2008 economic crisis and during the recent COVID crisis that benefits were extended both times by the federal and at the, in some cases, the state level. And there was concern, as I'm reading here, it says, why would we want to be dependent upon the federal government that they're going to come and rescue states? Well, that was an immediate concern at our first hearing, and I made a change to that. In this bill, it talks about, let me see if I can. right at the very beginning of the bill, it says notwithstanding RSA 445. And what that there does is allows the governor under the RSA, which is a state of emergency, to actually bypass the limitation on this new paragraph. The other reason is the majority of our unemployed in the state do go back to work less than 16 weeks, 16, 17 week period. We're at unemployment rates right now under 3%. There is a small percent at the very top end who do use all the 26. Now, there's always a small percentage that need it. And there are other avenues that I believe the state, local charities or whatever can fulfill that. But I do know for a fact that many utilize that number to the fullest because they can. And I want to read you, this was an email I got from an individual when there was an article put out on this bill. And I will use this individual as one of the exact reasons why this bill should be put in. And what it says is, I'll leave the name out, of course. From what I understand, you want to cut the weeks of unemployment by 10 weeks. I am in construction. I am laid off mid-November till mid-April. This means for me 3 months of no income for me or my family. I have a mortgage to pay, oil, and many bills to pay. So if this bill passes, can you pay my bills for those 10 weeks you want to get rid of? Where are your brains? Sincerely, X. So I responded to him. I'm not going to read you that, but I'll read you part of it. And it was, there are thousands of jobs open in New Hampshire. You could easily find a job to fill that gap. No. Where are my brains? Do you expect New Hampshire taxpayers to pay you to stay at home 5 months a year when New Hampshire businesses can't open when they need to due to lack of employees? I have a full-time job, a part-time job, and I spend at least 20 hours a week doing work for the State House. Where are my brains in useful time? And we had a further conversation on that, and for some reason I can't find the email on it. But basically, this is the type of individual that shouldn't be collecting unemployment, especially when we have the economy we have now. There are plenty of employers out there that would be happy to have this individual for 4.5 to 5 months a year working rather than collecting unemployment at home. So again, this is a great bill. It's not meant to target the Department of Unemployment Security. That was also mentioned in it. That's not the case. The case is to reduce unemployment taxes on business. It's intended to get people back to work as soon as possible, whenever possible, rather than having them collect unemployment. And that's the bill.
All right, thank you, Representative Turcotte. Are there any questions of Representative Turcotte from senators, since House members have had a chance to speak with them? Senator Daniels.
Thank you. And I think Representative Turcotte has appropriately brought out many of the arguments why I would oppose this. I think you've done a good job in articulating that. My understanding is that 87% of the claimants right now do not use the maximum 26 weeks, that the average duration of benefits is 14 weeks, which is less than the 16 threshold that you've set. When I was in the House for 18 years. I spent all 18 years on the Labor Committee. And so I know a little bit about the Unemployment Trust Fund. And what I can tell you is that Unemployment Trust Fund and employment security in general are probably some of the most stable funds we have in state government. They have survived the ups and downs of the economies back in 2008 and again around 2000. I'm really hesitant to start tinkering around with a system that really has been working well. And I guess one of the questions that I might have, because I know right now the claims are at a 30-year low. There are only 17 to 1,800 continued claims, where pre-pandemic they had 4,000. My understanding in talking to the commissioner is that they're going to be reducing the employer tax rate 0.5% in the fourth quarter of 2022 instead of the first quarter of 2023. So that's being accelerated. So I guess my question is, with all that going on, and what do we hope to gain on this? Because it seems like the things that are being put in place are the things that are already happening and better. It's sort of like, the minimum wage, it's already up there, so why do you need to push it up?
I think the example I gave of the individual that I read the email is a perfect example. We're not looking to change the entire system. We're looking to improve of it. What will happen with this, it will not make our current system worse. That won't happen fiscally. That's not going to happen. The goal is to make it better. How much better? That'll be remain to be seen. As I said, there are a number of states, Florida in particular, some of the other southern states who have applied this, and the results have been remarkable. I don't expect ours to be that remarkable, but no matter what happens, it will improve our system, whether it's minutely or quite a bit. Again, my goal is for those small percentages of people who are, or a percentage of those who go to full 26 weeks, we believe do not need to be going to 26 weeks. And I gave you, when I got that email from that gentleman, I said, yes, this is exactly the individual this is trying to get back to work. There's no reason for that individual, in my opinion, to be sitting at home 5 months a year collecting unemployment when he can go out. And I mean, right now, the average unemployment is fairly low, and that's why we have a decent system to begin with. Right now, I think we're at about an average of $350+ a week. Somebody going out today, you can't go anywhere and not find a job that starts you at $20 an hour or less. You start doing the math on that, that's a lot more than $355 or $350 a week. So again, our current system, I'm not saying it's bad. I'm saying this will improve it. It's as much a conceptual idea as it is a numbers idea. Once it's in, if we find 26 doesn't work on the top and maybe 24 is better, that's fine. If we find that 16 weeks on the bottom is too little, maybe we increase that. The original bill started out with a 12-week on the bottom, and after listening to different testimony throughout the extensive time we talked about this, I made significant changes to the original bill to bring things more, to make it more, I don't want to use the word compromise, but palatable, I guess would be the word. But where we ended up with, I think, is very, very sane. It's very common sense, and I believe we need to go forward with it. Thank you.
So let me just ask a couple of other questions of the House members. I'm assuming that Section 1 municipal bridge appropriation, everybody is good to go with?
Absolutely.
I'm assuming that Section 2 DOT apportionment appropriations of $30 million, everybody's good to go with?
Yeah.
I'm assuming Section 3, the $1 million for body worn dashboard camera fund appropriation, you're good to go with? Okay, we're making progress. Section 4, the highway surveillance prohibited, everybody good to go with? All right, so Then a new addition was the DOT Dixville Colebrook Road. My understanding of that is that this is something that's necessary for the Balsams. The construction costs and the $4.1 million would not happen until such time as the Balsams had fulfilled their requirements. So that's obviously a new House position. Any senators with questions of the House on this? Representative Umberger, you want to, probably went through finance, so you might want to talk about it.
Thank you. This request came in from the folks in Coos County. And basically, this is a road that the state currently owns. It appears that when they redid, is it Route 2 across there? Is that the main, no, it's not 2, it's whatever. The main route across from Errol to Colebrook, that they redesigned the road and abandoned, or not abandoned, but this section of road was there. So the, what the goal is to upgrade this road, not to highway standards by any means, but rather to upgrade the road and then turn it over to the town of Colebrook and Coos County, because it is located within a, anyhow, one of those things within Dixfield Notch, which doesn't have a quote-unquote government. So it would go between Coos County and Colebrook, because the road does go into Colebrook. And the key thing I think that you mentioned is that these dollars would not be spent under any circumstances until such time as the Balsams has sufficient dollars to actually make some progress on building their resort. So it's
Yeah, and that's outlined from lines 24 through 28,
Right.
29. Senator Rosenwald, question?
Yes, thank you. A question for Representative Umberger. I noticed that the appropriation doesn't have a year in which it's drawn, so we're probably trying to appropriate in some future budget?
no,
Or is it this biennium and it's not lapsing?
it'll be a non-lapsing because of, we don't know when the Balsams is going to get the financial requirements to move forward. We have heard all kinds of dates as to when this is going to occur, but we've heard those dates in the past. And until such time as they are viable, this will not occur.
So if I just, is it your intention that we appropriate the money from fiscal 2023? Do we need to specify that?
No, it was for it's out of 2022 money.
Where do I see that? Well, I'm looking at the side by side.
Yeah, if you look at the bill, it's on page 2, number 4.
Okay, I was looking at the side by side.
The reason 2022 is not specified is still in 2022, correct?
But yeah,
question for Representative Umberger. My understanding is that, as you stated, this money would not be appropriated till all the permits and everything was all set. But it's also my understanding that neither the town, the county or the town of Colebrook is interested in owning this road.
No, it would transfer to them.
Okay, because
I mean,
my understanding was that because neither the county nor the town of Colebrook were interested, that the transfer of ownership would be to the landowner, being Balsam's redevelopment.
Okay.
Well,
No. Yeah,
specify.
that's correct. Yes. So it's the county, it's a combination of the county and Colebrook, because the road does extend into Colebrook. How far in, I'm sorry, I don't know.
Okay, and follow up. And then the 4.1 million, my understanding is in transferring a road that normally the state would upgrade that road to an acceptable level before it is transferred. But in this case here, the state would still pay for it, but only after all the permits and everything else was in place. Is that correct?
It's not only the permits, it's the viability of the balsams.
Yeah.
And that to me was the key. That we weren't going to, the state isn't going to do anything with the road until such time as the balsams has their funding.
Okay, thank you.
Are senators okay with this? So,
Just one comment on this particular, and actually the bill is in its global sense. This one here, there were a few of us that were actually opposed to this, only because when you're looking at the total, I think the proposed cost right now for the project's up to over $300 million. So when you look at a $4 million project that's going to be solely for the benefit of the Balsams Resort, you're looking at just slightly over a 1%, proportion to the total project. Now, I will say, although all these other sections, Senator Bradley passed the House, they passed the House because HB 1337 was amended. I can assure you this bill, like a lot, SB 401, like a lot of the bills that came out without amendments that were placed on there, there's a lot of opposition in the caucus, in our caucus. So just something to think about. Thank you.
my question was, for the senators, okay, this provision, it's in the House version of the bill, and I think we are.
You need to turn your mic on.
Thank you. I think the senators are okay with section 5 of the bill, which brings us now to section 6, where obviously there's some discussion. So if it's all right with everybody, I'd like either Commissioner Kapadas or Lavers to maybe answer questions on the unemployment piece. All right, are there any House members that want to question? Not yet. Okay, so my understanding is, and I'll start, when you testified on House Bill 1337, the department testified in opposition, is that correct? Correct. And do you want to add anything briefly? This is not really a public hearing, but we have another 20 minutes, so since this is the focal point of the bill.
I think one of the things we'd just like to add to the chairs as well as the committee members is, the unemployment rate continues to fall, and I don't know if you saw today's release or not, but it went down to.
Yeah, you got to.
How's this, better?
Better.
So I don't know if you saw today's release or not, but today's release indicated the unemployment rate fell to 2.3%, which is the lowest it's been since 1988. And, the other thing that we wanted to mention, the exhaustion rate for those folks that go the full 26 weeks, it's 17%. Of those, 16 to 17% of those people that go the full 26 weeks when they're collecting benefits. And as it was indicated previously, there's, the average is about 14 weeks right now of people collecting. I mean, our goal is to get everybody back to work as soon as we can. I mean, we have virtual job fairs that are taking place all over the state. We have a job portal, which businesses are online with us, and anybody making an inquiry, the inquiry goes directly to the employer. I mean, the biggest issue isn't this what you have in front of you. The biggest issue is trying to find workers to get back to work. That's the biggest issue that we as a department are encountering. I haven't had any business ever come up to me indicating that my unemployment taxes are too high. I mean, what they're coming up to me saying is, where are the workers? And to me, that's the number one issue that we have at Employment Security, is trying to find additional workers to get back into the workforce.
So my understanding is the current unemployment tax, based on third quarter 2021, is 1.69%, slated to drop in the fourth quarter of this year to by 0.5%. So it would be 1.19%. Is that correct?
Well, the 1.19, Senator, the 1.19%, we have a new number on that for the fourth quarter of 21, and that number went to 1.72. And the reason it went up was because of the number of new employers who registered in the state to do business. And if it's a new employer registering in the state, their rate is 2.7%.
Okay, so roughly it'll go down to 1.2%, which is where you were before the pandemic.
Yes.
Okay. Another question that I think in our conversation, Commissioner Kapadas, was the disincentive created for part-time workers who now have the ability to work part-time, collect some unemployment, less than the $427, $427, but if it was capped at 16 weeks, in your view, they would relinquish the opportunity for part-time employment to just collect the full 16 weeks. Do you want to elaborate on that?
I mean, that's what our thought is that's what would happen. And it doesn't necessarily mean the 427, it means whatever their weekly established benefit amount is. So say they're making $240 a week and their benefit amount is $270, they could be eligible for an additional $30. And those part-time workers, I think an overwhelming majority of those workers are in the fields that are really, really hurting right now. So if they drop out as well, I mean, we're talking the hospitality field and we're talking the retail field. If they drop out as well, then it's just going to be more of an issue with restaurants and the retail industry of where do we get our workers?
Yes, go ahead.
Can you expound on that, please? Is it your position that if we cut the maximum weeks back, that the part-time workers are going to then no longer, I didn't really understand that. Could you clarify that?
Yeah. So if you were cutting back, you'd be cutting back 40% of what they're currently at if they go to the max, which is 26 weeks. But if they're in part-time employment, they could be eligible for more than 26 weeks right now because they're only getting a partial benefit.
Would that not then encourage them to stay part-time versus go full-time? How does that, your concern is then that they won't work part-time, they won't work at all, they'll just collect the maximum 16 and move on?
Yeah.
Thank you.
Other questions of the commission? Senator Daniels.
Thank you. Could you address Representative Turcotte's situation where you have, say, a seasonal employee and they get laid off for the winter? What is their expectation? Now, I expect that they're probably still going to have to look for work, but would you continue to pay them over the winter for unemployment, or would you expect them to pick up one of the many jobs that are out there?
So Senator Daniels, with an individual seasonal employment, so your construction industry, landscapers, bus drivers, school cafeteria workers, they are allowed to collect during their off season. Right now, if that off season is less than 11 weeks, they do not have to search for work. That was a change the legislature made, I believe, last session. But if that period of unemployment is going to be longer than 77 days, or those 11 weeks, those individuals are required to search for work each and every week that they are filing for unemployment. They do that right on their unemployment claim that they file. They provide detail to the department as to what their work search contacts were, what employers they reached out to, what other activities they participated in. Perhaps it was one of the virtual job fairs the commissioner referenced, but they're required to do that each and every week if that their seasonal layoff is going to be longer than that 77 days.
Follow up? If somebody, let's say, is a construction worker and they were going to be out for longer than 77 days, would they be expected to take basically any job that's available, or can they narrow the scope and say, I'm looking for a construction job?
So they'd be required, so take a step back. If the construction worker, if their return to work date is more than 77 days from when they were last employed, they'd be required to search for work the entire period. So they wouldn't have a work search waiver during the first 11 weeks and then have to work during weeks 12 and after. They'd be required to search the entire period. With regard to what types of work they are required to accept, they are only required to accept suitable employment. And so in terms of addressing whether an offer of employment is suitable, we look at what your wages earned prior to your layoff were, what the wages are that are being offered. We look at what the commute is. We look at the work duties that are being required of you for this new position. So if an employer were to contact us, let us know that they made an offer of employment to the individual, we would then do fact-finding, find out whether that was a suitable offer of employment. If we determine it was suitable, that would then stop the eligibility for that individual.
Thank you.
Representative Roy?
Thank you, Senator. Do you have any statistics on how many seasonal workers collect and how many that you shut off because they turned down suitable employment?
On the number of individuals, they have a claim, have a issue on their claim because of being able and available, or a work search, or an offer of employment. I don't have off the top of my head. When you look back to prior to the pandemic, 2018 and 2019, we had taken a look at the number of individuals that collected during those two periods and their benefit year had expired. So they finished their eligibility during those two periods. We had about 7,000 individuals that went above at 16 weeks or more. Of those 7,000, a little bit more than 2,000 were in part-time employment, meaning they had part-time wages that were reducing their unemployment benefit. And because of that reduction to their unemployment benefit, that's the logic that we follow for why that part-time worker, if they are capped at 16 weeks, that they would not have any incentive to take that part-time employment. Better to take the full benefit for the 16 weeks rather than taking a partial benefit for those 16 weeks. But it was a little over 2,000 individuals that were in part-time employment, likely in the service sector. We had, of those 2 years, there were a little over 25,000 individuals that collected benefits over the calendar years 2018 and 19.
Thank you.
Are there any further questions? I just have one. My understanding is prior to the pandemic, New Hampshire and Florida had almost equal unemployment tax, and they were the two lowest states in the country. With the prospective
reduction of 0.5%, where would that lead New Hampshire to be ranked in terms of the unemployment tax? Do you know that?
Senator, that is correct. So prior to the pandemic, 2019, New Hampshire had the second lowest unemployment tax burden in the country. We were at 0.14% of UI taxes paid compared to total wages paid. That's how they compare each of the states, because each state has different taxable wage bases, different rate calculations. So they look at those two numbers to compare each state. Florida was at 0.12%. So virtually a dead heat prior to the pandemic. There's a lag in that data, and with the lag and the fourth quarter having not occurred yet, it's tough to say what those rankings will be, but I would expect with New Hampshire going back to having fund balance reductions, meaning having reductions to employer tax rates with the fourth quarter of this year ahead of schedule, that would accelerate New Hampshire's return to having one of the lowest unemployment insurance tax burdens in the country.
Okay, great. Yep.
Thank you. It just occurred to me. So back to the part-time workers and the 16-week issue. If I heard you correctly, you said that if we were to change it, it would disincentivize them to find work earlier. They would just as soon collect the whole benefit and stay home for the 16 weeks. How could they do that if they have to search every week for a job and show you they've searched every week for a job when we have so many jobs that we can't fill? How's that even possible?
Well, I assume everyone makes decisions the way I do. They actively search for work. And the biggest motivational tool in New Hampshire right now to keep our duration as low as it is, at average duration being right around 14 weeks, having an exhaustion rate that's at 13%, is our weekly benefit amount. We have the lowest weekly benefit amount in the region. We are right along states like Arkansas, Mississippi, Louisiana for our average weekly benefit amounts. That is one heck of an incentive to get back to work. When you look at average private sector weekly earnings right now compared to our maximum benefit amounts, it's about a 31% wage replacement rate. Individuals really can't afford to remain on the unemployment program for longer than they find that next job. We assist them with finding that job, but with our weekly benefit amounts being as low as they are, that is really an incentive to keep that duration low. So I would like to think that everyone, as I, would immediately be actively searching and immediately finding employment. However, if you look at just looking at the dollars side of it, an individual that is going to be capped at 16 weeks and is, say, eligible for $300 a week in their weekly benefit amount, someone that was more likely to take a part-time job during those weeks is going to be less likely to do that. But again, we like to approach this that everyone is actively searching for work. We hold them to that each and every week. But our weekly benefit amounts being as low as they are really drive people back to employment.
Okay, this room is going to be used for another committee or conference starting at 1. I'm going to suggest that since we agree on the first 5 sections of the bill, and clearly I think it's safe to say we don't agree on section 6, that we come back tomorrow afternoon at 3. Representative Abbas, you and I have a committee of conference that starts at 1:30 tomorrow afternoon. Do you think 3 is safe?
On it, so that's. I know
All right, is that okay?
Okay with Councilman.
Okay, we will, I think the right phraseology is be in recess until 3 o'clock tomorrow afternoon, room to be determined. Commissioners, thank you very much. If one of you could be back here tomorrow to answer questions, that would probably be helpful.
Good afternoon. It's 1 o'clock. I will open the Committee of Conference on SB 445. And House members, it looks like you have one microphone for the group, so you get one question. If you can just introduce yourselves. Peter?
Peter Leishman.
Gerald Griffin.
Maureen Mooney from the town of Merrimack.
Tracy Emmerich from Hampton.
Jeff Bradley,
Aaron Hennessy, Senate District 1.
Jay Kahn, resident of Keene, Senate District 10.
So I thank the House for agreeing to Committee of Conference. After the bill went through the Senate and House process, it was brought to my attention that the way that we set up the fund with the appropriation amount may cause some difficulties for the spending of the funds if it's an approved purpose, but not an approved purpose for that fund. So I spoke with the Commissioner of Business and Economic Affairs, and the amendment in your packet will show you that we've taken out Section 1, which is the appropriation of the $122 million, and added a section below the conflict section. And it says the Commissioner of the Department of Business and Economic Affairs shall submit a quarterly report beginning July 1st, 2022 to the Fiscal Committee of the General Court, which includes the number of grant applications received by the department, a list of the grants approved by the department, including the broadband provider, the political subdivisions covered, and the dollar amount of each grant, a list of grants denied by the department, the details of any successful or unsuccessful appeal of a department decision to deny an application, the details on any federal coronavirus capital project funds authorized by the American Rescue Plan Act of 2021 appropriated for reasons not included in the broadband matching grant initiative, and the details of any remaining available federal coronavirus capital project funds authorized by the American Rescue Plan Act of 2021. So it, in effect, does the same thing as the appropriation, having the department come to fiscal for any reasons that are legitimate reasons for the fund, the monies received from the federal government to expend them on that are not in the broadband fund. But now they'll just be doing reporting versus coming to fiscal for approval to expend those funds. Does that make sense? Thank you.
I would move amendment 2022-2031S.
Have a second? Thank you. Discussion.
So just to be clear, Senator, this amendment is going to get rid of Section 1 in the bill as amended by the House, replace Section 4, and then Section 5 remains the same in the original bill, as does Section 6.
There's some renumbering. So
Okay.
once you take out Section 1, then you renumber it. And then, let me see what.
Okay. So
this, the new Section 9 will go under the old Section 5. It'll be part of the old Section 5, which is now the new Section 4.
Okay. So everything else remains. Thank you.
Any other discussion? Okay, House? I will, yes? Do you want to confer with your colleagues? Oh, okay. Sorry. Sometimes you guys like to take your vote separately from us, so
and lead your own vote. I didn't know if you'd prefer to do it that way. Okay, thank you. Senate's position?
Yes.
Okay, thank you. I don't think so.
Good afternoon. This is the committee of conference, and we are discussing Senate Bill 420. This is a recessed meeting, and what we did last time was to pass Amendment 2005, so that's taken care of. And I have a letter from Mark Manganiello at the DOE, so there'll be a technical correction. You look at this side by side to, whatever it's, Section 3. Instead of saying RSA 82 and 83, it will be RSA 82 and equalized payment in lieu of taxes.
Yeah, that's the same as
Yes.
Roman 4 in the House version. That's in it.
There's the Roman 4 in the House version?
Yeah.
Okay, okay. So I think if I have everything right, what we have left is to discuss the increased eligibility. Any discussion on that?
I think on the, if you're talking about the education tax credit.
Yep.
We'd like to pursue that through new legislation next year and drop it from this particular bill and go with the amendment that we introduced regarding the accountability that we did the other day.
Mhm.
So that if you're going to go with, which version you got here?
So,
So Madam Chair, is that, so what I'm hearing is that the Senate would accede to the House version with the LAD amendment to section, is it still section 1? The section, it's section 1 on page 2 of our side by side.
yes.
The technical correction still in section 1, Roman 4, but deleting section 4 related to the education tax credit. Is that correct?
Correct, yeah.
Yes, that's correct.
Any further discussion on that?
We're all good? Yes.
You're all good?
We're
You're all
out of
good?
here?
You good, Senator?
Is it to a later date, so it's not part of this, correct?
You,
Next biennium.
yeah,
Next Friday, okay?
you heard, we have the amendment.
I have to.
Yeah, so we have,
did act on the amendment.
yeah, we did that last time. And then we have a technical correction from the DOE on saying in lieu of taxes instead of RSA 83 something.
That's what
Right,
in the House.
so that's in the House
That's
amendment.
why we
Right.
have it there, because they
Yeah,
gave
right.
us that
Right,
from Mark. So we're good.
it's funny, we didn't get that, you got it ahead of us.
So just to summarize again, the Senate, we are acceding to the House version with the LAD amendment for section 1, Roman 2, section 1, Roman 4, the House amendment, or the House version, and with the deletion of section 4.
Right.
And any adjustments that need to be made to the effective date section, if any.
What do we have? 1/3, effect July 1,
No, there's
2022.
effective date is fine.
Right. And the other part is taken care of, so. Okay, do we have the Senate?
You're probably deleting section 5. Yes.
Yes. Senator Prentice, you okay with it? Senator Hennessy?
Yes.
You're okay?
We're good?
Good.
Thank you for coming.
Great. Thank you, Senator.
Go home, take care of that dog.
Get a sick dog?
No.
No, he goes every lunch to walk him.
Oh, I see.
You take turns with your wife.
Okay.
You're gonna stay for a while.
Oh, good.
Yeah. It's been more than a month.
We left one of our pups in the house alone. We came home and the leg of the World's piano had been chewed off. My wife was ballistic. Golden retriever. Puppy. Peter.